Welcome to this edition of the Real World of Employment Law podcast. My name is Clyde Findley. I'm a lawyer here at Berenzweig Leonard, and I have with me today Declan Leonard, who is the guy when it comes to employment law and employment litigation, and I'm going to be cross-examining him. So he's in the hot seat today, so say hi, Declan.
Clyde, it's great to be here with you today. Take it easy on me. I've seen you in deposition. I've seen you across the table from some witnesses, so be easy on me today, and luckily I'm not under oath, so I think we're good.
This is going to be easy.
All right.
Today's topic is employment litigation, specifically with respect to small businesses and what it's like and how they can avoid employment litigation. As lawyers, we often forget what litigation is like. We're used to it. But for someone who has not had it before, has not been in litigation before, it can be a really shocking experience. It's battle, it's combat, it's sneaky, it's a mess sometimes. And so we're going to talk a little bit about that and what it's like and how to avoid it. So I guess the first thing, let's pretend I'm a small business owner. What's the most common way that I might find myself embroiled in some kind of an employment law dispute?
Yeah, I think the most common, we hear about it all the time, I guess it's traditionally known as wrongful termination. An employee is let go by a company and perceives that there is some problem with regard to their being let go by the company, and they're not happy about it. And so they, oftentimes they'll consult with counsel or do something where they think, I've got to pursue this.
But I thought Virginia was an at-will employment kind of place. Can't I just hire and fire whoever I want, whenever I want, without ever having to explain this or justify it?
No, that's a great question. And the at-will employment doctrine, which, as you just noted, it basically is cited all the times. It's like, hey, look, you're my employee, but I can get rid of you at any point. The word that sometimes is missing when people talk about it is you can terminate somebody just the same way that an employee can leave. It's kind of like a two-way street. But it's got to be, when you're terminating somebody, it's got to be for a lawful reason. And so what we're talking about here and what we'll talk about today is when the employee feels, rightly or wrongly, that the termination was unlawful. That's when one of these cases ends up, turning into something bigger.
So when an employee decides that they're going to, file a lawsuit or go after their former employer, what do they do, and how can I, as the employer, avoid this?
Yeah, usually what happens is you'll either get something, the employee will send an email where they're sort of laying out their grievance against the company. They'll usually send it to the boss or to the CEO of the company. Or what will also happen sometimes is they'll go get an attorney, and the attorney will send what we call traditionally a demand letter. It'll come either in the mail nowadays, maybe by email a little bit quicker, and that's not an easy thing for a company to get.
So I won't get a lawsuit filed against me right away. I'm going to get a letter.
That's correct. You watch TV all the time, and it seems like the grievance happens in the morning and they're in court in the afternoon. But in real life, of course, things take a lot longer than that. So it's rare that you ever see somebody that's just going to lead with a lawsuit. That's correct.
Okay, so I'm running my own company. I'm off doing my thing. I'm used to dealing with problems all the time. Why do I need to hire a lawyer to deal with this problem? Why can't I just, if I'm getting a letter, I can respond to this. I can deal with this on my own, right?
And you're right. In some ways, you want to think that that's the way to go. You would hope that cooler heads would prevail, that the company owner could talk to this employee and in essence, what you say, talk sense into the employee and maybe smooth it all over.
Right.
In my experience, that doesn't often happen. And what could end up happening is if the boss or if the CEO of a company engages in those discussions, doesn't have a lawyer as sort of a buffer, they could make the problem worse. And I'll give you an example. If emotions get charged in a phone call, let's just say with a departing employee, and the boss says something that was maybe as perceived as a threat by the employee, what would happen is that could form the basis for an additional claim, which would be a retaliation claim. And so that's what I'd be worried about if they didn't have counsel. This is in no way designed to be a plug for employment lawyers. If anything, what we're going to be talking about here today, Clyde, is designed to short-circuit these disputes so that your life with the lawyer, the employment lawyer in your life as a business is more short-lived than long-lived.
So this is maybe kind of like a doctor who wants to know about an illness way in advance. You as a lawyer, an employment lawyer, want to know about a problem way in advance also, because you can sometimes knock something out without having to go to court at all. Is that right?
Very much so, and just the same way you wouldn't want me as a non-medical person to diagnose my own problems and try to treat my own things. Right. It really will allow you to short circuit the problem if you get good, competent counsel who's not looking to fan the flames of litigation, but rather looking to get a smart business resolution to a problem.
So I think I know a little bit about the sort of the employment dispute that might happen. And my understanding is that at first, an employee is required to go to some kind of agency and make their case before an agency. Am I generally right about that, or are there other ways that I might get into trouble as an employer?
Generally, that's right. If it's a discrimination case, a harassment, the things that we hear about, sexual harassment, gender discrimination, religious discrimination, disability, those all generally have to be raised at an administrative agency before you can actually go into court, before you can actually even start that court process.
Wow. Okay. So the employee has to go elsewhere first. They're not going to come fight against me in court. They're going to have to go to an agency and, I guess, clear a hurdle within the agency before they get, I don't know, they get a certificate or something that lets them go to court?
Yes,
what happens there?
They actually, it's interesting because you say clear a hurdle. It's not like really that they actually have to prove anything at this. It's really just biding time because they have to keep that there, generally speaking, 6 months. So they have to keep it at the agency for 6 months. And in that time period, the agency, in theory, is supposed to be investigating the claim. But at the end of that, no matter what the agency thinks of the claim, whether they think it just really doesn't have much merit, they couldn't substantiate it, they're still going to issue what's called a right to sue letter. And sometimes employees will get that right to sue letter and think that, oh my God, I've been legitimized. They're telling me basically, they're inviting me to go sue this company. Everybody gets a right to sue letter. So that's your invitation to, and that starts the clock to get into court.
So as an employer, how do I get involved in that administrative process, or should I? What should I do?
Yeah, from the moment that you get, we talked earlier about, let's just say a demand letter or even an email from the employee. Right. The worst thing you could ever do is ignore any of those things because that's only going to make it fester and make it worse.
But if I ignore it, I don't have to think about it.
That's human nature, you're right. But we all know how that works in our private lives, and it doesn't work in the business world either.
So the sooner I get involved, and actually the sooner I get my lawyer involved, the better, even if it's an administrative context, right?
Yeah, because what you want to do is you want to speak with one voice throughout the whole process, whether it's you responding to a demand letter even before the administrative phase. You're going to be putting things down that later on could be used against you. So for instance, if you start saying, well, the reason why we terminated you was X, and then later on at the administrative phase, we say, it actually was Y. We discovered that you did X, Y, something else bad. And then you get into court and you all of a sudden raise a third thing, that's not going to be good because some of the courts will say that you can infer discrimination, or at least there's a rebuttable presumption of discrimination when you can't get your story straight.
So if I can't get my story straight, if I have multiple explanations, the inference is I must be making stuff up because I'm discriminating.
That's right. That's right. And that's not a good position for a company to be in as they're defending one of these cases.
All right, so let's say that the employee gets this right to sue letter. What happens next? That's when they go to court?
Yes, they have 90 days. The clock starts ticking. They have 90 days to then file a lawsuit in court.
And what's that mean? Do I get a copy of something?
Yeah, it's mostly called a complaint. There's some other names that are used for it in various jurisdictions, but let's just call it a complaint. And it's basically a piece of paper. It's multi-pages, and it's basically in numbered paragraph forms. What are the allegations that this employee is making against the employer? These are not facts. These are just, this is what the employer says happened. Usually they are not fun and not pleasant for a company to read because they are not usually designed to portray the company in the most positive light. Let's put it that way.
And this is where, like, the deputy sheriff shows up in my office and serves me without complaint, right?
Yeah,
How can I avoid that?
Yeah, that's another reason perhaps to get counsel involved early on, is because if you know this complaint's coming, if your attorney knows this complaint's coming, the attorney can usually reach out to the other side and say, hey, we'll accept service. Service is that process where the sheriff comes or a private process server comes and basically has to hand you, it's kind of like real service. It's got to be kind of hand-to-hand service in most instances. That can be an unsettling process in a company. All of a sudden, the receptionist, the somebody in uniform is there to, is so-and-so here? I've got something I need to give them. And, word spreads through the office. I think it's always best to try to avoid that. And so an attorney can help prevent that and some of that embarrassment.
Can I avoid court altogether by, like, arbitrating or that kind of thing?
I mean, you can. So arbitration, there's two things, arbitration and mediation. But arbitration is the one that's kind of like, it's a substitute for court. It's where you and the other side go in front of somebody that you hire. It's usually a retired judge. It could be a law professor. It could be another practicing a lawyer. And you basically present your case to that arbitrator. You're paying that arbitrator. Usually you're splitting the cost, the two sides are, unlike when you're paying a judge. You're paying the arbitrator. That is a process, and you see that used in a lot of states. There are some pros and cons of arbitration, certainly.
But that's something that is usually in an employment contract, right?
That's right.
Or the parties have to agree to arbitrate.
That's right. And in my experience, it's usually that it's already an employment agreement. It's rare that after a dispute like this has arisen, somebody's claiming, an ex-employee's claiming wrongful termination, that they're going to say, hey, we're happy to arbitrate it. Because it does, it's supposed to be a cheaper process. Sometimes that happens, and sometimes it's not a cheaper process. It's supposed to be shorter. Sometimes it's not always shorter. So especially in our jurisdiction where we have the rocket docket, that's a quick one.
So if I'm a small business owner, do you think I should have employment agreements, and do you think I should have arbitration clauses in them?
So this is going to be my opinion. I think you should always have employment agreements. Sometimes companies will say, yeah, but they're an at-will employee. I don't need to have an employment agreement. But an employment agreement doesn't guarantee that an employee is being hired for a certain period of time. In fact, it's rare that I ever see an employment agreement that doesn't specifically say, pretty much at the outset, you recognize that your employment is at will, which means we can terminate, but you can also leave for any reason at any time yourself, too. So I think it's always important to have employment agreements. I generally, because we have such a good court system in our area here in Virginia, Northern Virginia, and the DMV area, we generally recommend that we don't have arbitration agreements in there.
Okay. I'm now find myself in court. I got a complaint filed against me. I've hired a lawyer. What happens next?
Yeah, so the next thing is, okay, so you're the company, you have been sued, let's just say for wrongful termination
I'm a
of some
defendant
sort.
now, right?
That company is now a defendant,
Okay.
Exactly. It can be intimidating. I mean, you're like, oh my gosh, it's, this versus this, and here we are, and sometimes you end up in federal court. That's intimidating in its own right. So the next thing that would happen is you respond to the complaint, and you can, the most common response is to answer the complaint, and it literally is called an answer, and you basically just go through the numbered paragraphs in a complaint, and you say, I admit this, I deny that, I have insufficient facts to even know whether or not I admit or deny that. So it's kind of like a paragraph by paragraph.
Okay, let's say I got the complaint, I file an answer, or we file some motion to challenge the complaint, but eventually we get to the point where all that's done and the case is moving forward. We're not going to go straight to trial, right?
No,
We're going
definitely
to go
not.
through this thing called discovery, which is a mess, and I think a lot of employers are going to hate it whenever it happens to them. So can you just give us a little summary of what happens in discovery and how I can make it faster, easier, better, get through this as much as possible, as quickly as possible?
Yeah. I mean, discovery is kind of the meat and bones of litigation. It's where everything really happens. The complaint, you can kind of put anything in a complaint. I mean, I hate to say it, but in many ways you can. There are some boundaries there in terms of it being frivolous, but you can pretty much put anything in a complaint. And then the answer is, again, generally, hey, I'm just going to deny it. You don't have the proof that proves it, so I'm going to deny it. when you get into discovery, it's almost like, you see in the newspaper, the fact checker section, we're gonna check your facts. This is kind of the fact checker process for what everyone's allegations are, because it's one thing for the lawyer to write something either in a complaint or an answer. But now here's where you have to kind of, I hate to say it, but put up or shut up in the discovery process, because you're going to have to answer questions.
I like the fact checker sort of phrase. I often tell people that if they're going to litigate, it's not about the arguments you make, it's about the evidence. And discovery is where you find and identify and show your evidence. And if you don't have the evidence, you can't make the argument.
Yeah, that's exactly right.
This is where discovery, that's what happens in discovery. You're looking for all of the evidence.
And you talked about it being a messy process. I mean, it is, because what it is it's inevitably fights over, give me these documents, you're withholding these documents, you're not producing this witness, you're not. So it is a messy process, there's no doubt. It's a necessary process in order to kind of weed out claims, though.
So when can I settle? When can I just make this case go away?
Well, I mean, there's no impediment to settling at any stage of what we talked about so far. At the time of termination, you may want to offer a severance. You may want to offer severance in an agreement in exchange for a release. You can settle and have discussions at the administrative phase, at the demand letter stage, and at the complaint stage. As soon as you get that complaint, you could offer to settle. Now, again, that's when you can settle, but there are tactical and strategical reasons why you would want to pick various time points within a dispute to try to settle it.
Like right on the eve of maybe a deposition or something like that.
Again, it must be human nature, because just in my experience, it often happens that way, that it's on the heels of something where a client, whether it's a plaintiff or the defendant, has to really pay attention, and perhaps, like you said, a deposition where you have to sit down under oath and answer questions, and that might be when settlement happens.
So let's just get this straight. A deposition is not something that's happening at trial. This is sort of a trial-like interview, but this is happening during the discovery process, right? So as an employer, I might be forced, I guess, to sit down at a deposition and answer a bunch of questions from opposing counsel, right?
Absolutely, 100%.
And I may not want to do that, and that might be a really good time for me to make a better settlement offer than I've been making before.
Yes, that's true, and it's not unheard of for that to happen. Yep.
So all of this is sounding like it's costing a whole lot. How can I limit the cost of all of this? Is there a way to buy insurance to get out of all this?
Well, within the last 10 years, it's gotten a lot more popular. So, companies have all kinds of insurance. They have premises liability insurance. They have workers' compensation insurance, which they're required to get. And they have other types of insurance. Well, there's something called Employment Practices Liability Insurance. It's EPLI is the acronym for it, but it's Employment Practices Liability Insurance. And more and more companies are getting this. And it basically insures, basically what happens is if you have employment practices liability insurance and you get one of these demand letters, or you get a lawsuit, or you get an administrative claim, you basically call up your insurance company, just like if you had an auto accident, and you say, hey, got one, and they will often, they will then come in and defend you, meaning they'll hire a lawyer for you. Sometimes they'll pay your own lawyer just to defend you on it. And again, these come in all shapes and sizes, but sometimes they'll even pay a judgment. So yes.
How big should I be as a company before it makes sense to buy some kind of employment litigation insurance?
Yeah, it's a great question. I mean, I've usually said, if you're just a dozen employees, if you're a young company where everyone kind of knows each other, the risks it's really kind of a risk opportunity cost type thing, because you are going to be paying premiums. My experience is the premiums are not cost prohibitive, but I would generally think you would want to wait till you get to like in the 24 employee realm, where you start really being subject to a lot of the federal discrimination laws before you really want to jump into EPLI insurance. But, you can certainly get it for peace of mind when you're smaller.
So give me a little bit of advice on how I can avoid employment litigation in the first place. Is this just a matter of, treating employees well, or is there anything else I can do to avoid this kind of problem? Yeah.
I mean, look, some of these disputes are inevitable. It's like curing the common cold. I mean, it's kind of like there is no pure cure for this. And in my experience, of course, I think companies treat employees by and large quite well. But there's always going to be situations. I mean, it's you spend so much time in the workplace, sometimes more than you spend at home, and so you think of all the emotionally charged issues that happens within families. You know, we see our fellow lawyers on the domestic relations side always handling like really, really volatile issues and emotional issues. Well, listen, a lot of that same stuff happens in the context of a workplace. And so, you know, what a company really needs to do and what supervisors really need to do is just be very in tune to. I wrote an article one time called "Fairness Should Guide the Firing Process." Supervisors should really be in tune to how is what I'm doing being perceived by the employee also. Is what I'm doing going to be perceived as fair or not? And you're never going to win on all of these matters. But I think trying to keep emotions out of a decision, trying not to really kick somebody when they're down. Try to treat them with dignity, try to treat them with fairness. And they're not going to be tempted, in my experience at least, to run to a lawyer to complain that there might be a problem.
So be fair and communicate. I don't think you're saying be transparent, but communicate well.
Communicate's a very important thing. I mean, if you go into a termination meeting and you say, we're letting you go, and then, well, why are you letting me go? I've been here for 3 years. I thought I was doing pretty well, and our lawyer said we don't have to tell you. How's that going to be perceived? And what it does is it breeds suspicion that, you know, there must be something behind it that they're looking to cover up. And so, yeah, I think communication is a really important thing. Don't sugarcoat it, because you also don't want to tell white lies when you're terminating to spare somebody's feelings, because as we noted earlier, if you don't tell the real reason, it's going to come back to bite you.
So going back to the beginning, assuming that something like this happens, the best thing to do is to get a lawyer involved as soon as possible, because they can help dig you out of any problem that you might inadvertently dig yourself into.
Yeah, ideally, exactly. And ideally, Clyde, you would already have that counsel, you know, as part of your trusted team of advisors, so that, you know, it's not like you're paying that lawyer every day or every week or every month. I've got clients who they may not contact me for a couple of months. That's fine. I'm still their lawyer. And guess what? I still have all the historical knowledge of what has happened within that company, so that they're not calling me reactively in a panic saying, you don't know who I am, you don't know my company, but I'm getting sued for X discrimination. Can you help me? That's not the best use of your time. So this is certainly by no means a plug for employment lawyers, as much as, frankly, it probably will limit our involvement in these disputes, because you know, it's kind of an ounce of prevention will work better down the road, I think.
Declan, great discussion. Thanks for joining me here today.
Yeah, Clyde, and I think this was an important one. I appreciate that you had this idea, because, listen, we take it for granted that small businesses are going to know, like, all of this lingo that we lawyers carry around every day. But what we hope this will show them is that trying to help demystify the process just a little bit, so that they can carry on their business.
Okay, great. Thank you, everyone, for watching Real World Employment Law.